Hello, everyone. Welcome. Good evening, and welcome to our sixth Black Voters Matter Policy Corner of 2023, where we will recap all the things that happened in the United States Supreme Court in these crazy legislative sessions in 2023. We saw the United States Supreme Court rule on cases like affirmative action, Moore v. Harper, Allen v. Milligan, just to name a few. All three cases directly impact us as Black people as we continue to fight for and protect the hard-won protections of the previous 60 plus years and continue to demand that our elected officials pass the Freedom to Vote Act and strengthen our democratic systems. Over the last year, at least 322 restrictive bills were introduced in 45 states. Of these 35 bills, there are many that are still moving through legislatures that are still in session. Among those bills, more than half would restrict access to mail voting, 7 would impose stricter voting ID laws, and 6 would increase the risk of faulty voter purges. We also witnessed unprecedented attacks on Black and other marginalized communities through bills like Don't Say Gay and all-out assault on Black history in states like Florida, as well as our right to fair representation. We remain in unprecedented times that require our vigilance to combat these current and ever-present threats to our constitutional and democratic norms by the radical right. 2023 was an incredibly busy legislative year on matters of race, democracy, and voting rights. Tonight, you will hear from our dynamic Black Voters Matter policy team featuring myself and our illustrious legal director, April Albright. And as always, our policy corners are safe spaces for our righteous outrage, where our policy meets power and action. And I would like to note that tonight we're switching things up a bit and we'll be answering your questions throughout the evening. Without further ado, I'd like to introduce my fearless leader, April Albright.
I don't know about fearless, illustrious, but this is meant tonight to be a casual conversation. Ryan and I will have these discussions. Quite frankly, all of us will have these discussions at Black Voters Matter. We see this space, the policy corners, as a way to bring the kind of conversations that we have internally as a team and as an organization overall, and have this conversation with each of you because, we are in this together. And so tonight we kind of wanted to talk a little bit about two institutions that are very important to shaping the policy of how we live, in this country, but aren't often talked about. We always talk about the president and the executive branch, like we learned when we were in, elementary and middle school. And we often talk about the United States Congress, right? We talk about, the House of Representatives and who's the speaker and what's happening there. And we talk about the Senate. And by no means are we suggesting tonight that either of those branches are unimportant, because they're absolutely important, right, to the discussion. But what we've seen, right, in past years is that there are two arms that are shaping us in even more aggressive and regressive ways. And so Ryan and I tonight just kind of wanted to share some information that we have to make sure that we are all informed about these particular branches of government and how they're affecting our lives, and how just this year they've made some decisions that are quite frankly hurtful and frightening at the same time, and that we are going to have to be vigilant about. And so what are those two institutions, right? The first is going to be Article 3, right? There are 3 branches of government that we all learned in elementary school. And we, like I said, we also talk about the executive branch, and we also talk about Congress. But what we don't often talk about until something breathtaking happens is the third branch, the judicial branch, the U.S. Supreme Court. And we've seen just these past 2 years how much their unchecked, and I say unchecked, power is impacting our day-to-day lives in ways that, we are losing fundamental rights that this country allegedly held dear. Now, as a Black woman, I say that very cautiously, because fundamental rights have not always been afforded to Black people in this country and brown people and other marginalized people. In fact, these fundamental protections that this country seemed to hold dear, that were enshrined in its Constitution and has been previously protected by the Supreme Court, that Article 3 branch, we've seen an erosion of that. And so when you're already a marginalized community, when you already have fragile rights, then when they start to take actions that make those rights even more fragile, then we as a community have to stand up and respond. But the only way we can stand up and respond, right, is if we know about it. And so tonight, it's about knowing about some important cases, not a whole lot of cases, that the Supreme Court heard this year and made some important decisions. But nevertheless, we're going to talk about that. The other area that is shaping policy in this country in a very regressive way is what's happening in the state level, right? What's happening in these state houses, what's happening in the southern state houses in particular, because unfortunately, the Supreme Court and a lot of these, state houses, particularly in the South, are in a very kindred relationship right now, where things are birthing, where laws, regressive laws and policies are birthing in these state houses and being signed on by a lot of the federal, courts, district courts, and the Supreme Court. So they got this very, very evil, almost demonic friendship that is changing the shape of this country, even though you may stay in states where you believe progressive laws are going forth, not only in the state house, but in the governor's house, but you see your rights in your state being eroded because of this, unholy relationship between these state houses and the Supreme Court. And so tonight, Ryan will be unpacking, some of those laws that are happening in these states. Because as we've seen what happened with the Dobbs case that was in Mississippi, right? That it doesn't matter that the case is happening in Mississippi to go into your neighborhood in the state of New York or the state of California and other places. It doesn't matter anymore because of that unholy relationship. So we want you to know about it. We want you to know what's happening in these state houses around issues like voting rights, right? And privacy rights that relate to marriage, that relate to education, that relate to, who you can love, right? And so we want to talk about that tonight. And then I'm going to punctuate it and talk a little bit about some cases. So I want to bring Ryan on because she's just going to, talk about that little round robin, of cases and laws that are happening in these state houses that are often go unchecked, right? Until we look up and again, it's affecting all of us. So Ryan, what, in your, research this year and, as you do in your work, you are always following what's happening in these state houses. Let's talk a little bit about, some of these regressive, laws that were introduced and signed on to. You and I were talking earlier, right, about, this assault of what's happening in these state houses where they're trying to empower themselves to remove people from office that do not think like they think. Those are just some little small examples. You have a lot more, in your arsenal that you're going to discuss tonight, but I'm going to turn it over to you so that you can enlighten us about what's happening in these lily red states with these very, very regressive state laws that might become national policy.
Well, I want to add that these individuals in office that have been removed were duly elected by the people, by the way. So not only are they in violation of their respective constitutions at the state level, they are in violation of what voters wanted, which is even a bigger deal than what's already law in those states. So I would like to just start out with some of the legislative trends I'm seeing, just to drive the point home how the scale of these assaults on our democratic principles and the things that we hold dear and quite frankly take for granted. So I'll start with something that I learned about probably at the end of last year. It is a electronic registration information center called ERIC. So a lot of people are probably asking themselves, well, what is ERIC? I know I did because I'll be the first to tell you I don't know everything. So it was something that Florida this year decided to leave. So I was like, Want to know why? And it's basically a way for state election officials to maintain accurate voting records as humanly possible, detect possible illegal voting if there is any, and it helps states reach out to potentially eligible but not yet registered voters. So folks that haven't quite made the full decision to participate in the process. So the states that left are should be no surprise to most people: Florida, Alabama, Louisiana, Ohio, West Virginia, Missouri, Iowa, and Virginia. I'm sure that there will be others, um, especially those with supermajorities, with right-wing leadership. And we will also start to see the influence of AI in our elections, for better or for worse. One of the things that we discussed during my meeting with Leadership Council on Civil Rights, collectively as a group, we were really thinking about what are the ways in which AI can impact our elections moving forward, for better or for worse, and how to prepare for that. The other trends I'm starting to see are the need for for legal protections for our election workers. I don't need to remind people about what happened in Georgia, the attacks on people simply trying to help people get through this voting process, right? Um, we've got supervisors of elections resigning in Florida in numbers that we should be concerned about. Just generally attacking folks that are just trying to do their job and making sure we have free and fair elections and that they run smoothly. Criminalizing election-related activities. Florida, looking at you, kid. Uh, Florida is leading the way on a lot of these trends I'm seeing, all the way down to the removal of state officials because the governor disagrees with the ways in which and how they do their job.
Isn't that amazing? Like,
Yeah.
it's the criminalizing of people who are literally just doing their job.
Mm-hmm.
Removing of folks just because you're in disagreement.
Because I don't like you.
Right. Well, let's unpack some of those like that you were able to find, and if you want to, you can start in your state. You're the good. Well, I guess your former state.
My former state. I made the great escape in June. So Florida, it's two that really struck me as a violation, not only of our rights as voters, but just as human beings, attacking our identity as people. So Senate Bill 7050 is what I would like to call the follow-up to the attacks on vote by mail we saw last year, SB 90, which I was directly impacted by. I was purged from the vote by mail rolls and ended up voting early because, again, I live, breathe, and sleep this work, so I knew what to do in terms of resolution, but that might not be everyone, right? So there are a lot of people impacted by this because they weren't required to tell you that you have been purged, right? So the onus is now on the voter to make sure that not only they've not been purged, but also that they know what to do when it comes to 7050. So they've added even further restrictions than what SB 90 was doing last year. So the biggest being the attacks on civic engagement organizations. It's not just voting rights third-party orgs. It is civic engagement, and voting rights orgs generally. The governor's goal is to drown those orgs in legal fees, fines, and fees. Sound familiar? You'll notice that there is the attacks on Amendment 4 after it was passed. Like direct democracy work, he does not like it, right?
So we're talking about your NAACP organizations.
Yes.
These type of organizations that they're going after, they now created in this session a law that, makes it so that they also, right, can find themselves facing different kinds of penalty when doing that kind of civic engagement work that we do when we just go out in the streets and we just telling people to vote and things of that nature, or we're just trying to help people be able to exercise their right to vote.
Yep. It's no secret we called our elections by 9:00 because Florida counts the vote by mails as they come in versus waiting. So, and even the governor admitted how smooth those elections went. Yet, what a difference a year or 6 months makes for him. The other bill that I want to highlight, I call it Stop Woke. Um, it is encompassing of what the governor perceives to be the right of parents. I preface that with saying he wants white parents to be able to discriminate, and that's what this bill allows, right? It encompasses don't say gay. It threatens what and whose history is taught in the classroom. He's attacked curriculum at the collegiate level using this bill. The bill number is SB 266. HB 999 was the bill version in the House. And it was vague and cruel for a reason. There were even concerns around whether or not he would use the bill to attack our divine nine, our affinity groups, our very core of who we are as a community, right? So those are the big two for Florida that I would say are super harmful. There are others, don't get me wrong. Florida has been on a roll, especially when it comes to gun ownership. We passed permitless carry. And the direct impact of that, we saw that in Jacksonville. Florida is also the home of Stand Your Ground, which directly led to the death and murder of Trayvon Martin. So those are just three of the things that I saw that are deeply impactful to us as a community.
It's impactful, and we're witnessing it. And I'm really glad that you spotlighted those two, because what we are seeing, and it's not just Florida, right? But as we talked about at the beginning, it is this unholy relationship where you see in these state houses these antiquated, backwards, regressive laws being created and then followed up and held as constitutional when it makes it up to SCOTUS, and we all find ourselves having to live under the shadows, of these types of laws. And so we've seen this assault aggressively in Florida to attack the history, our history, to try to present curriculums that make slavery seem palatable, right? That it seemed okay, to make it so that issues like diversity, right, where we're talking about, communities all being able to share in the resources and opportunities in a state, now being frowned upon, and in fact, leading to the termination of teachers, in the state of Florida and other places. And so these policies are not just in Florida, but what they're doing, though, is giving us that very important insight. And then, of course, you couple that with, restricting voting even more and making it so that the very people who are kind of those shepherds, making sure that people's voices are heard at the poll, now creating criminalization of those people just to kind of continue to silence the voice of communities as they fight against policies like what's happening with education. So they are too, but they are mighty. And if we allow for, these policies to stay unchallenged, we may all find ourselves, again, no matter what state you're living in, having to grapple with the fact that your history, or a revisionist history, right, of what this country is and the ills and the evils that this country has produced, be buried. And, as they always say, people who do not know their history,
doomed to repeat it.
But so, what else do you have to share with us in these other states?
Well, a state that I thought was safer. I hate to say that in the context in which we speak, but North Carolina was one of those bright spots. But not to be outdone by Florida. Unfortunately, there were some members of the state legislature that switched parties, and that turned into a supermajority in the General Assembly, which led up to, I believe it was a 12-week abortion ban. We had Don't Say Gay, North Carolina version. All of these things are framed in the parental rights bill, which is on its surface innocuous enough, but it's not really. It's an attack on people's identities and just existing, right? So, but the big election bill that I would like to highlight in terms of voting rights is Senate Bill 747. The governor did veto it a couple of weeks ago. However, over the last 5 or 6 years, the state legislature has done its best to erode the powers of the governor. So you have to add that on top of some of these bills. North Carolina's good for if it doesn't work the previous year, we're going to bring it back and try it again and see what happens. So, and 747 is one of those bills. It started out as an election integrity bill, I believe, last year. And now it has now made it so far to the governor's desk. He vetoed it, but the state legislature has the power to override. So we must now also push and fight back against that gubernatorial override, right? And so this was a package of bills that influenced where boards of elections could get funding, the elimination of the 3-day, oh my goodness, it was early vote. 3-day grace period. Excuse me, that was the word for mail ballots, shortening the window when absentee ballots could be returned to their respective county boards of elections. So this it's situation critical. It mandated a voter purge program that would unjustly target people suspected of being non-citizens. We all know where that can lead to, just blanket discrimination of different groups and othering of people, right? So that is the biggest thing, but those gubernatorial overrides are also critical to also to state out loud on this panel. That parental rights bill, SB 49, just like the one in Florida, it attacks our LGBTQ community members, and I wouldn't be surprised if they also use it to implement a similar Stop Woke North Carolina version bill. But because that's how it started in Florida. It started out, oh, well, we've got to protect parental rights, right? Gender affirming care ban, HB 808, 574, fairness in women's sports, again, an anti-trans bill. I hate to say it, but these are copycat bills from other parts of the South, and it's scary. Yeah, it's scary. And then the Supreme Court in North Carolina changed hands last year when it came to the voting maps. This court decided, I don't like what you decided.
Which was unprecedented of itself when you have a decision by an appellate court, right? Even though the justices may be different, it becomes, once it's signed, it's an actual order. And it is very extraordinary for the same court, right? That's the North Carolina Supreme Court, who received new justices to go back and revisit a prior opinion by the same appellate court just because you have new justices. And so there's a lot of aggressive, and that's why, tonight, one of the things that we want to really, really bring home, right, is that we've got to pay attention to what's happening at the state levels. We've got to pay attention to what's happening at the Supreme Court, because while those places like Congress and the President of the United States is important for us to pay attention to, a lot of our bread and butter and what's happening to us in our states, in our cities, in our neighborhoods, it's happening local and in the courts, And so I think, I'm glad that you are, kind of spotlighting these parent right bills and the assault, on sexual orientation and our transgender brothers and sisters. I'm glad you're talking about that. And I think a lot of people in our community, mistakenly feel like, well, those things don't apply to me. Right. You're not my issue.
That's a mistake.
And it's a huge mistake, because the point you just made, right, which is it starts there because they believe that it's a wedge issue, right? They believe that only a few people are going to respond to that and care about that. And what happens is they go in, they change the law, and then they expand its application. And so then it becomes not just, right, the woke agenda doesn't become, hey, just the transgender children, but it's making its way to now the curriculum dealing with the history of Black folks in this country. Yes. And so our struggles, right, in many ways, especially when it comes to policy, right, yes, are uniquely tied in this country in a way that we need to stand together as opposed to opposing each other, in a way that the enemy, right, are those who seek to continue white supremacy in this country, want us to do. They want us to be divided. They want us to say, oh, that's an abortion issue. That's not my issue. Until they realize, right? Until we stand back and realize how it trickles over into our community in some very unique ways. So I'm glad you talked about that, what's happening in North Carolina from that perspective, because we've got to understand, right, that it's not going to stop. That these new laws that are being created is not just meant to attack one of our members of our community, but in essence, it's going to attack us all. And we all have to be able to recognize that and stand in the gap for all of our communities, all of our vulnerable communities, and all of our marginalized communities. So in essence, our effort tonight is to help us do that, help us to see ourselves in each other, no matter where we are or what our journey is in this life. So thank you for, highlighting those two laws. But, I like that you're going to talk about Alabama, because a lot of folks have written off Alabama, and Alabama is my home state, right? That's, I was raised in Tuscaloosa. Yes, Roll Tide. Yep. But I will say that, and so folks have just written it off.
Yeah.
But again, not to be stopped, but Alabama, has, been doing some things. And I want you to highlight it because, folks have written Alabama off, but Alabama organized this year, right, their communities against these regressive bills, and they won. So can you talk a little bit about that? Because we want to talk about some victories tonight.
Shout out to RJ, because he killed it at that press conference. Okay. But again, these attacks on Black people, Indigenous, our other communities of color, in the effort to protect white supremacy, go at the very heart of how we're educated, who's educating us. Many of these bills are leading to teacher shortages, which is going to increase the importance of school board elections at that. So with Alabama, there was a bill, HB 209. So that was going to criminalize absentee ballot assistance. Come on. And I always used to say, and I was raised with this saying, so goes Alabama, so goes the South. So goes the South, so goes the rest of the country. So whenever I hear somebody say, oh, that's this state, that's just that state. Oh, trust and believe is coming to a city and a state near you. Case in point, the book bans in Missouri. The gerrymandered maps in Wisconsin.
Come on now.
Okay, this is a concerted effort where our enemies are playing chess, and we need to hop on board, or we're gonna miss that train, right? Mm-hmm. So HB 209 would require those performing any sort of voter assistance services to either, you had to be related, probably be family with the voter, or appointed by an elected official. Now, you and I both know it's a lot of civic engagement organizations on the ground helping folks, educating them on what the processes is in the state to register to vote, where to go, polling locations, all the things that are necessary to make sure our folks get out and turn out to vote, right? Not all of us have access to a car, for example. A car is still a luxury in many parts of the South, especially those rural parts. Okay? So this has deeper impacts than just me being allowed to assist someone with their absentee ballot, right? We have a whole group of folks, especially our disabled folks, that can't just pop over to their election office, right? Drop boxes were convenient, I know, for me, because I work so much. I had to go drop my ballot off in the drop box at the supervisor of elections office, but I understand the privilege of where I stand with that, right? So, and if you don't fall into that narrow group, what are you supposed to do? And that could jeopardize people's willingness to turn out to vote. If you take away the things that are convenient, that make it easier to vote, then you are punishing people. You are suppressing their vote. Okay? Now, we defeated it. So this is not a Debbie Downer story of any kind. However, as always, if Republicans fail, they try again. And the sponsor, Representative Keel, has said, I intend to reintroduce this bill in 2024. So
we're going to be ready. We're going to be ready. Go ahead.
Yes, we will be ready.
Our community organized.
To fight it a second time.
That's
and
right.
We will be ready to fight you in court if we have to.
Exactly.
So that's Alabama.
That's organizing.
I don't want to, get on them about those maps. I'll let you do that. But they did the same thing, Florida did. We're going to do what we want to do. I don't care what you want. It's not about you. So, but that's Alabama. That's one of the bills that stood out most to me in the state of Alabama. So
I think Texas is important because something else is on the horizon. The horizon. And something else that I don't think that we are really clear, right now, because I'll talk a little bit about the affirmative action decision, but I don't think that we're really clear about the nuanced ways that these state legislatures and assemblies are going to attack and utilize that case that we're going to talk about in a minute to further limit, right, our presence. And I say our, I mean Black and marginalized, people, on universities and institutions of higher learning. And I think ultimately we're going to start to see it trickle over into corporations where folks are working. And so can you talk a little bit about, SB 17?
Oh, Texas. Texas has historically kind of done whatever it wants to because, it used to be a republic. It used to be a part of Mexico. So on top of the fact Texas tends to meet every 2 years, I think they're one of the states that does biennial legislative sessions. So I say that because when something egregious passes, you locked in until the next session. So it's even more important for our Texas brothers and sisters to understand why these state legislative sessions are important. You might not get another chance. You might not be able to fight it in court. The Fifth Circuit is, I believe, one of the most conservative courts in the country, right? So that's also not a guarantee as well. So SB 17 came up. It was part of this wave of attacks on diversity, equity, inclusion at the collegiate level. This was prior to the decision on affirmative action. A lot of states didn't wait on it. They just went ahead and did it. So Greg Abbott in June signed this bill prohibiting DEI offices, in addition to another codifying tenure restrictions, which impacts our professors. He even had the audacity to argue that DEI programs push policies that, and I quote, expressly favor some demographic groups to the detriment of others. So again, this thinly veiled belief that places importance on how white people feel. And the version of history that is safe. All right. History is not here for you to like it or dislike it. It is there so that we do not repeat the mistakes of the past.
And I think that people just underestimate because, when you see these diversity and inclusions, and I'll talk a little bit about it when I talk about the cases, but like what Justice Sotomayor and others dissenting, in the case that dismantled affirmative action talked about, that what they're moving forward in this illusionary colorblindness, right?
Race neutral.
Right. This whole race neutral, we are in, we're in this colorblind era, and what we know for certain, right? And I spent many years, 8 years as a supervising attorney for the Department of Education, OCR, and what we know unequivocally, especially in these southern states and their institutions, is that our admissions rates, when I say our, I mean, Black and brown, students continue to range from 10% or less of college campuses, right? So, right. So there was no new data that demonstrated that we had reached an era where there was not disproportionality in admissions, right? In fact, the data clearly shows that despite the number, our proportionality in this country, it is not reflected in the admission process of most of these institutions of higher learning, as well as America's corporate structure, right? Especially when we talk about those environments, that quote unquote are coveted, right? And jobs that are coveted. And so we know that. And so despite the evidence that shows that it's not representative of the number, of Black folks who live in this country, they make a decision as if it is. And so we are in a situation now where they're making these policies, like what you see in Texas, and we've said all night, it's not going to stop there, right?
No.
But we're going to start to see an already dwindling number of admissions of Black and brown students become even more challenged, become even more reduced, because as Justice Ginsburg said in an earlier decision, in the Shelby decision where it was dismantled, the Voting Rights Act was dismantled. It's as if saying that an umbrella, right, that you're not wet anymore because the umbrella is working. Well, the policies in higher education weren't even really working. But now we won't even have that layer of protection. And we'll talk about that even more. We're going to run out of time soon. And I just want you, if you could, just close out a little bit with talking about some victories that we had and some progressive models that we've had that we want to see happen all around the country in both, Ohio as well as Michigan.
All right. So it's not all doom and gloom, but it does emphasize the importance of getting involved locally and the importance of direct democracy, things like ballot initiatives, constitutional amendments, things like that. So Ohio, issue 1, where Republican Party was trying to make it harder to get things on the ballot through ballot initiative. So they wanted to go from a small, just a simple majority. I believe that was 50%. And then they wanted to move that above 60% for a supermajority. Now, they knew well that abortion rights, reproductive justice was going to be on this ballot. That has been the wave, if you will, of states like Kansas and Kentucky, of all places, where, all right, I want to see if the people want this in their state. And overwhelmingly, they did. So Ohio was like, well, we can't have that. We can't have that. We don't care what you want. Do as I say, not as I do. Right? So issue 1 on August 8th, Ohio voters rejected it. It's a direct attack on their right to have things put on the ballot and up for a vote. Now, Ohio voters will have to turn around and vote again in November, but that was probably the biggest victory, because Ohio tends to be a bellwether state for many an issue. So, and then Michigan, I mean, I don't think we have enough time to go through all the expansion of voting rights that
but give us a few though, because we want to know.
Okay, so I would be remiss if I didn't bring up SB 13 and SB 259 with context. Prop 2, again, where the voters decided on, the ballot initiative around that was passed last November, making it easier to vote in a secure way. Because Michigan is the state where the crazies tried to kidnap the governor.
Okay.
So, and look, we had some election deniers try to infiltrate, certification, all those things. So, Prop 2 passed to protect Michigan elections from those things. Then, Big Gretch, as she's commonly referred to in my circles, signed SB 13. That moves the state's primary to February, which strengthens Michiganders' votes and voices in the presidential primary. Then in May with SB 259, bipartisan legislation, mind you, ensuring that absentee voter ballots from the military and overseas voters are counted if received up to 6 days after the election. Now, she went on a expansion of voting access spree that I have never seen. And so I hope that catches on other places where there's a little bit more power over the state legislature. We had SB 370 implements requirements to allow voters to fix clerical errors with their ballots. That's a huge win. It also requires prepaid postage for all absentee ballot applications. Again, another win. An envelope saving voters time because you know how we're busy. You know, we can't all take off. You know, a lot of us work 9 to 5s. Saves you time and trips to the post office. 373 is a Detroit bill. It's a rep from Detroit sponsored this one. So I have family in Detroit. Allows Michiganders to use their passport, their tribal photo ID, military ID, student ID to identify themselves before they show up to vote.
And that's a big deal because in some states,
students,
those are disqualified. So yes, that's great.
And there are a lot of states that are very strict about which forms of ID you can bring.
Like, so for example, you can bring a gun registration, but you can't use your student or your tribal.
Yeah.
So yes, that's why this is so huge, right? Yeah. And why it's so expansive.
My personal favorite, which was one of the bright spots in Florida, I was able to track my ballot. So there are a lot of us out here that don't trust the mail. They don't trust the systems in place. And in many ways, it's warranted. So now in Michigan, Senate Bill 339 establishes a website for Michiganders to track their ballots, to make sure it got there. I know that will give me peace of mind as a voter. It'll ensure that voters are notified when their vote is received and counted, and inform them of any errors and offer a solution. They need to go fix it. So that's just a little bit from Michigan. So she went on a voter expansion spree.
And we're excited about that. That's why we wanted to end with that. We wanted to end with Ohio, our legislative overview, because there are victories being made. And when we know what happened in Michigan, we know that the people in Michigan organized and from top to bottom put in progressive-minded people to solidify, even more protections. And so they give us a North Star, right? So wherever we are, that if because Michigan was also considered one of them places where you couldn't get a lot of, progressive, measures passed. And what we see in that state can be mirrored in other places. If we work together and we organize in a place like Ohio, right, where different coalitions of people, came together, with different interests and made sure to send a notice to, those state officials in Ohio that, hey, you're not going to take away our measure to use the ballot in order to increase our protections, right? Especially in a state where they are inclined to take them away. So we wanted to end that legislative and have those discussions because it shows that the power is still with the people. That if we organize ourselves, no matter who's in these state houses, right? And no matter what judges are there, there's still ways for us to get the victories that we need to provide the protection for our people. And we are believing that even in Atlanta right now, where people are trying to write off what's happening with Cop City, we believe the people's voices will be heard, right? And that, Cop City will be stopped in Atlanta and hopefully be stopped everywhere else. And I did not want to end this session without talking about that. But I want to quickly talk about the Supreme Court, because as I said earlier, you do have this kind of, unholy relationship between state houses, creating the kind of laws and policies that Ryan just kind of went over. And, there are so many more because, as she said, it was over 300, regressive laws that were created. But we just kind of wanted to give you a snapshot of the types of laws that are coming out and that you may see that we see as a trend, right, in all these other places and probably including your state. And so we're going to be sharing some of these laws on our website, even after this, highlighting what some of these things are and what their implications are for you day to day. But in closing this, we want to talk a little bit about the Supreme Court. As we've known the Supreme Court to be over the years, it can be both a friend and a foe, right? Historically, the Supreme Court, when we think about the Supreme Court, we think about the years of how the Supreme Court upheld the legacy of slavery in this country and upheld, the legacy of denying, Black and brown and other marginalized communities like the disabled community, our indigenous brothers and sisters, right? Women, our LGBTQ community, denying us access to that fundamental rights. But yet we've also seen historically, right, when the courts have found a way to be our friend when needed, right? In the Brown decision, expanding, ending years of segregation and separate but equal doctrine. We've known that in other cases, in terms of, voting cases, upholding, some very important aspects of the Voting Rights Act. We know that, abortion has been protected at some point, by the Supreme Court. We know that marriage, right, when states try to limit even, interracial marriages, we know the Supreme Court has stepped in and said no. Right, in cases like the Loving decision. And we know that in 2020, we know that the court finally righteously said that, sexual orientation was in fact protected under, Title VII and other civil rights acts. And so we see these various ways where the court has stepped in. And this session was no different. We know that in the area of voting rights, there were two pivotal cases that were pending in the court's last session. And one of those cases, again, my hometown, Alabama, and, the Milligan decision, where, the lower court decided that, the way that the maps were drawn, congressional maps were drawn in the state of Alabama, was preventing Black folks from having another district in order to have their voices heard in Washington, D.C. And there's a lot of legalese that goes with that, but I'm just going to make it plain, And so that case went to the Supreme Court, and many people were unclear how Justice Roberts and other conservative members were going to handle that case. In fact, most people predicted that Justice Roberts would take this opportunity to give that fatal blow to to the other remaining section of the Voting Rights Act that provides those very vital protections, for marginalized communities. And yet the court agreed with the lower court. The court agreed that that Alabama's map was denying, right, an opportunity for Black voters in the state of Alabama to have their voices heard in Congress, and required them to go back in the legislature to go back and redraw a district or congressional maps that permitted that second district that allowed for Black voters to determine who their representative will be. Now, that's a great decision. We know the fight is not over. If you've been reading the news, you see, in fact, my younger brother is a state representative who's on the committee, who's looking at those maps. And we see right now that foolishness is happening. So even though the court has said to go back and draw that second congressional district, it's not happening. And we may find ourselves back in court trying to defend and trying to make sure that we create that second district. But the court did uphold that lower court decision and require the state to do so. We also were looking at what was happening in North Carolina, right, in the Harper decision, where many voting rights, litigators and proponents and activists were worried that the court was going to adopt a very extraordinary, way out there legal theory that basically says that in terms of the election clause, which gives the state the power to administer elections, that power was with the state house and would be unchecked by the state Supreme Courts. That's an extraordinary made up theory. Didn't have no roots or precedent or history anywhere. But, they feeling themselves because the Supreme Court has been very much their friend. So they making up stuff and sending it up to the court. And yet the court did reject that as well. And so we sat back and we knew, we bated breath and saw that they, after last year's assault on some fundamental rights in this country, were very concerned about those two cases this year. But The court relied on that more inclusive part of itself and decided not to tear down Section 2 of the Voting Rights Act and not to allow for this very extraordinarily out there, made up legal theory to exist in North Carolina. But while we applauded and we're happy that we got another opportunity to use the Voting Rights Act to give protections to marginalized people in this country, as you know, the court removed affirmative action, which has been a protection that has been, heralded throughout the years to provide access to higher education, for Black and Brown and other marginalized people in this country. And the court put the fatal blow and said that it is unconstitutional. And so right now, what does that mean? When people hear affirmative action, a lot of our elders in our community understand its significance and its hard fight. But a lot of us young people, younger folks don't know. But what it basically means is that race is no longer a factor. And unfortunately, the court, relied on, ignored a very long legacy, of the oppression of Black people and Brown people and other people to come to that decision. Basically ignoring that the 14th Amendment and all of the other civil rights acts were in essence put in place because of what was happening and what had happened to Black people and other marginalized people in this country, and provided a race neutral interpretation to say that the 14th Amendment treats us all in terms of non-discrimination or factoring in race, ignoring the legacy of discrimination that has happened and is still happening in this country. And so a very vital tool that is in place, and has been in place for years, is no longer in place right now. And so we are waiting and trying to determine as activists, how do we move forward and make sure, that, members of our communities are not going to be victimized even more from the removal, of this very important doctrine by the Supreme Court this term. And so in many ways, returning to that darker side of the Supreme Court history, the one that said in the Dred Scott decision, right, that haunts the Supreme Court, that the white man has no rights, that the Black man has no rights, that the white man is bound to respect. So that's where we are with that case. And then finally, there's another case that the Supreme Court, and I want to end with, because I do think it's important. The 303 creative case, which is where, the court, it was a Colorado case, and the court decided agreed with the plaintiff who said that she did not want to use her website company to create wedding invitations for same-sex couples. And she said that it violated her First Amendment right. And the court agreed with that. And why we all need to be concerned and watchful for this case. And again, as I said earlier, a lot of people think it's not a race case. It's not a disability case. It's not a case involving me, but it's involving a member, of the gay community. And so how does that affect me? Why is that case important to me that they came down that? Because, as I said earlier, the court in 2020 had determined that sexual orientation was a protected class that was deserving of the highest scrutiny, right? In other words, the state has to show that it has the most compelling reason in order to do something or not do something. It's a protected class. And the Supreme Court has had a history of saying that the First Amendment, right, does not overpower, right, the acts that seek to protect a protected class. This country has had a legacy, right, initially, where it involved race, where even the court would say that the First Amendment trumped the rights of people of color. It took a long time for that to change. And so when we sit back and we watch the court break that precedent, right, where now the First Amendment can trump a protected class, because sexual orientation, according to the court, is equivalent to race, gender, right? Disability, and some other classes. And so if we are all protected classes now, and you're willing to go against and say that someone's First Amendment right triumphs that, what will prevent you from applying it now back to us in the way that it was done many years ago in this country's ugly history? So while you may say that case does not apply to me, what I'm inviting you tonight is understand that in the world of precedent, in the world of this Supreme Court, who has been willing to bust years of hard-fought precedent to give us protections in this country, it has demonstrated a willingness to throw it away. And so as we think about these court cases, as we think about these state houses and what they're doing and what they're producing, we have to be mindful that they're not going to be our friend. And just like we're diligent when we go and we see who's running for president, we have to be diligent in who's running for governor. We have to be diligent with who's running for state house. We have to be diligent when who is running for these state judicial offices, because they are shaping the policy in this country. And we have a very aggressive Supreme Court who has demonstrated its willingness to join and lock hands with those hell-bent on taking us back to a past that we fought to come out of. And so our session tonight is not just to inform you, but to inspire you to take this knowledge, to keep researching, to find out and stay informed. And don't just you be informed. Inform your neighbors. Inform your church members. Because we are in for a fight. And there were questions that were asked in the chat. And one of them was, do you think the courts in this country lack the ability to effectively address fascism? Absolutely. What we've seen is that the Constitution is only as effective as those who will enforce it. And so when you have, right, a court with judges at the highest level who are willing to ignore precedent, to ignore the North Star of a multicultural democracy, where more people are able to share in power and decision-making. When you have an executive branch who ignores the Constitution and instead decides that to implement what it wants to do, not just at the federal level, but at the state level, the courts are basically meaningless to stop it. How are they going to enforce it? If you're going to ignore an order, as we've seen happen in this country in recent years, openly and notoriously ignoring orders, the courts are rendered powerless to provide enforcement of it. So there was another question that was asked: how have interest groups and organizations reacted to these recent legislative updates? They've been organizing. And that's why Ryan, most importantly, talked about those wins that we've had, because we've seen across the country communities igniting. We've seen in places like Kansas that the community came together, passed an abortion initiative in places that they thought would never happen. Mm-hmm. But the people have come together and forged coalitions that have gone across race, gender, sex, disability, immigration status, and come together to fight to get these gains. So that's what we must continue to do. And we must fight for revolutionary policies, not just the policies that we feel, not just to defend the policies that exist, but we can demand, right, and organize around expanding the Supreme Court to put some more progressive minds, because the Constitution does not have a limit on the number of justices that can be on the Supreme Court of this country. And so we need to start making those kinds of structural revolutionary demands so that we can bring these changes that we need to make sure that all of our voices are heard in this country. And finally, there was a question. Has the Supreme Court stance on affirmative action changed in 2023 compared to previous years? Yes, it has. And we've known over the years from prior decisions, from the Bakke decision, from the Fisher decision, and I'm saying those names because I want you to be able to go back and do your own research. We've seen the progression of the court becoming less and less inclined to sign off that affirmative action should happen. In fact, Justice Roberts asked in the last case, in the Texas case, what's the value of diversity? That's what he asked during his oral argument. And it signaled to everyone where this was going. And so while the prior cases barely upheld affirmative action, right, this court took the final blow. So there was a time period where even though there were dissenting voices and opinions on the bench around the issue of affirmative action, we know that the court eventually would rule in favor of it to stay. Well, we know that that has changed. So Moore versus Harper, as I said earlier, was a radical, imagination of a policy that had no life or roots ever in American jurisprudence history. But despite that, though they brought that case anyway. And what that signals to all of us is they will go to any measure in order to push their agenda forward. And we've got to understand that. So I'm going to stop, Ryan, if you have anything you want to say to the people before we close this night out about what they should be looking out for or what can they do.
So I'll keep this brief. There are groups, the interest group question. So like you said, we have to organize at the rate or even more that these bad actors are organizing, right? So you have groups like a ALEC or a Federalist Society that are intentionally shifting our courts in a particular direction. Making sure you know who those judges are. So if you're in a state like Florida, we have this thing called merit retention. So you can change judges if you want. That's not the case in every state. Sometimes you're stuck with who you got to the next round of election. So it's important to actually know who they are. And sometimes you can actually look up some of the decisions that they've made, particularly on, some of the issues we've already discussed. And some of them list if they're part of these groups like the Federalist Society. And one of the ways you can tell that the ALEC bill is the language is similar. They'll just pick and choose, by state, how they kind of want to zhush it up, as I say, to fit where it is, right? Open Secrets is a site where you can follow the money. If you want to know where your elected officials' loyalties lie, that site will tell you who's giving what to who. And then I'll just leave you with this because I want to be mindful of everybody's time. And it's one of our core values: protect Black women, trust Black women. Okay. Now there are people, all skin folk ain't kinfolk, but for the most part, because we have quite a few Black women under attack by some of these problematic elected officials, all out removal from office, even. We have an attack on a Supreme Court justice in North Carolina as we speak, because she's the only Black woman on the bench. That we must always protect Black women, because they're getting to the point where when they don't get their way, some of these bad actors, they will remove you. They will try to accuse you of not doing your job. They will, even though the people duly elected you. So there are many ways in which you can stay woke and pay attention to what's going on. School boards, y'all, I can't scream it loud enough how important, especially parents who aren't on board with the banning of books. Toni Morrison is even banned, y'all, in some of these states. Ridiculous. Okay, you've got schools in Escambia County, Florida, that the school libraries are sitting empty because they don't know what's allowed and what's not. It's just sheer ridiculous anti-democratic behavior going on. So that's what I'll leave you all with. This is not a hopeless situation. It's just that we've got to be more vigilant than ever. And the things that we fought for over the last 7 years, we've been a little complacent about, but they need protecting all day, every day. Because none of this is promised, right?
Mm-mm. Nope.
So,
And we've always shaped policy.
yes.
We've shaped policy when we go to the polls. We've shaped policy when we've protested. I always tell people, we got the Voting Rights Act because we protested.
Mm-hmm.
Right? We changed the Montgomery policy around where we could sit on the bus by not driving and riding on the bus. We have many tools that we can use. And yes, we've used litigation.
Yes.
And yes, we've run for office. And yes, we've lobbied. We've done all those things. And we voted. And so there are many tools that we can utilize in order to continue to shape the world that we want. We don't have to take it as it is.
Nope.
Right. And that's what we believe in our policy department at Black Voters Matter. We believe in the power of the people to change policy. And so we hope, we know that you could have been anywhere tonight in this last hour, but we are so grateful and thankful that you just kind of sat here and listened to Ryan and I do what we do every other Friday when we have our one-on-one. And we talk about the state of affairs of what's happening, around the different laws in this country. And we also talk about how we're going to help to bring the change. So thank you for signing in. We love you. And we look forward to being out in these streets with you, fighting for the nation that we all want to see. Have a great night.